Hello, everyone, and welcome to Commercial Collection Agencies of America's next 20-minute talk. Today is January 23rd, and I am so happy that there are so many people joining us. Um, we have got record attendance once again, so I'm very happy about that. And it's nice to see a lot of familiar faces and names and also new people. So, welcome to the new people. Commercial Collection Agencies of America has opened this up industry wide, so it's not necessary to be a member of CCA of A. However, if you like this content and you are interested in membership, then there is a link in the invitation that you received to learn more about membership. My name is Annette Wagner, and as I say whenever I take the microphone, I have the pleasure and the distinct honor of being the executive director of Commercial Collection Agencies of America. The executive director gets to do all this stuff, but also is very supported by the board of directors. Um, Before I turn it over to the incoming president, I am going to tell you, mark your calendars. The schedule is also on the website. We are scheduled through May with these 20-minute talks. So February 12th, we are going to welcome Joe Schur from Relling, Goldstein, and Crane. That's February 12th. March 12th, Brian Cloud from Cloud and Willis is going to be with us. April 2nd, Vivian Uchitel from VHU Law. She will be with us. That's April 2nd. And then in May, Chip Stacy is going to be with us from the Stacy Law Group. We're going to get that exact date and post it on the website. But the schedule is on the website, and you'll be able to register for all of those TMTs. I'm also happy to report that CCA of A has created a strategic partnership with Mike Gibb from accountsreceivable.net. And if anybody was on the webinar last week, we had a panel of CCA of A members speaking about commercial collections. We have now scheduled another one, and we'll have a monthly spot with Mike Gibb. Mike Gibb, I don't know if I'm sure most of you have heard of him. He currently is in Texas, and he is running ARMTech, a very large conference for the collection industry. On February 19th, a week after our February TMT, we are going to present advanced asset location strategies for commercial collections. So that is going to be a very interesting session. Okay, with much pleasure, I am going to turn this over to CCA of A incoming president, Alex Rosen from American Financial Management. Alex is going to introduce our speaker. If anyone has any questions or comments, please put them in the chat and I will pose those to our speaker. Alex, take it away.
Thank you very much, Annette. And first, I want to give praise to Umberto Matz, who's also on, for launching the 20-minute talks. Great idea, Umberto, and I'm glad to take the baton and run with it in terms of primarily getting the opportunity to introduce each speaker. So I have the distinct honor today of introducing Jeff Rubin. Jeff serves as managing partner of Taganoff, Rubin, and Rubin, a law firm concentrating in workers' compensation, creditors' rights, collection, probate, real estate, and general practice. He has been with the third generation family firm since September of 1989. And that was the same year that he was admitted into the Florida bar. So he's been practicing for 37 years. He's also a part of many associations, including CCA of A, of course, the Independent Standards Board of associated with CCA of A, Martindale-Hubbell, the Orange Bowl Committee, and the U.S. Olympic Committee. So without further ado, I'm going to pass it over to Jeff.
All right. Thank you, Alex. And thanks, Annette, for inviting me to join the 20-minute talk. Happy to give a little bit of my thoughts on items. And one of the things that I wanted to have an opportunity to speak with you all about is sort of, what we as collection attorneys like to see when getting new claims. It just makes it so much easier if we as collection attorneys can get everything up front so that we can really try to nip it in the bud and try to get on top of things as much as we can early on in the collection process. So I started putting together 15 ideas or thoughts that I thought would be useful, not only in information, but also in documentation. Well, that 15 has turned into around 50 or 60 different thoughts. So what I did is I put all this together, emailed a copy of it to Annette. So Annette's got all this, and she'll spread copies around to everybody. So no real need to take notes unless you all feel a need to. So just to start off, the first part is in the creditor information. One thing we'd really like to see, especially if we're going to end up filing suit, is we need the actual legal name of the creditor, not a trade name or anything. So we need to actually know that name of it. So when it's as reported, with that appropriate creditors state, where they may do their annual filing. So that would be very important. Maybe if it's a subsidiary of another company. So the actual legal name of the company would be very important to be able to provide, especially up front, so they've got all that information. If they're doing a DBA, provide the DBA or fictitious name of that company as well, so that we know exactly that it's, the ABC Corporation doing business as, Joe's Lemonade or something like that. It's always nice to have that so that we have that perfectly put together. Um, and also whether or not they're authorized to do business in the state of where you're sending it. So one of the things that it's nice to have is to know that that ABC Corporation is actually authorized to do business, let's say in the state of Florida, if the claim is being forwarded down here. Normally what they'll do is they'll go ahead and they will file a registration, maybe as a foreign corporation doing business in a particular state where they may do business, such as like in the state of Florida where I'm from. I'm from Miami. The address is important. And I'll get to the reason why that in a little bit. The phone number, contact person. I don't necessarily reach out to the contact person within the creditors. I always try to seek, uh, a contact with the collection agency and the particular collector. But if there's issues that come up and say, listen, really would love to connect with them. Most of the agencies that I work with, trust me and will say, all right, sure, contact Joe Smith or Jane Smith and say, contact her directly, email address, anything that you can provide. That's the general information on the creditor. For the debtor, it's pretty much the same thing. Once again, the legal name as in that particular state. In Florida, we use sunbiz.org, and that can go right on the website, and you can identify the actual name of the debtor. Is there a DBA? Is there a fictitious name? Sometimes I'll get it and I can't figure it out. I'll go to the fictitious name, and then I can say, oh, it's Joe's Lemonade Stand. Oh, it's really the ABC Corporation. And you can then make that identification, connecting the dots of the actual name of the debtor. If you have it, an FEI number, because we can also do searches with FEI numbers to locate a particular debtor. Once again, same thing. If regard to a subsidiary of a company, if it's a subsidiary, it's nice to know that as well, so that we can identify the actual legal name of the debtor. Address, obviously very important. These days, since COVID, we're finding a lot of companies may operate out of somebody's house. If they do, love to know whether or not is it a residence? Is it a complex? Townhouse. If there's a townhouse, do you have a townhouse number or apartment number? Or if it's an actual business, the business address. Phone number, which makes sense, obviously, contact person's name. If you have the contact person's name in the accounting department, that would be even, that would be helpful as well. Maybe obviously email address for the accounting department, for the principal officer. Any information concerning contact would be ideal. If you know websites available, sometimes websites you may think that you put an ABC Corporation, but actually they may have a certain website that has a different name. So if you have that, that would be helpful, because then we can go right to the website to find information about that particular debtor. Also, whether or not they are, registered in the state. Like I said earlier, if you have it, the Secretary of State report. Usually, I download those immediately, but if you've got them, that's great if you can supply that as a part of your collection. You all probably already have all this information, and it's there, so it's easy just to add it on one of your attachments when you're forwarding a claim. Next is with personal guarantor. Certainly, we see a lot of them these days with applications or a separate document for a personal guarantee. Um, Full legal name of the personal guarantor would be amazing. Whether or not they're married, if you have that information, the addresses where you think that personal guarantor can be served. A lot of times, the registered agent will be, the registered agent of the company could be the same person as a personal guarantor, but they may be just the registered agent and they may have the registration address at the name of the business. But then again, you may have that person's name listed as a home address. So if you have that home address, if it's something that's readily available, maybe in an application or information you have obtained, that would be helpful. Uh, Another thing that I look at is, especially in the state of Florida, and I know, Gil Singers I can see on the line as well. He's very familiar with this as well. Is homestead exemption. We love our debtors here in the state of Florida, and that's one thing I check for as well, whether or not the property that the particular person owned, whether or not they have homestead protection, because then we have issues with protection of any claims that may assert against the claim against the person if in fact they have homestead exemption. Social security number, date of birth, if you've got it. One of the reasons why I like that information, it could help if we ever have to do a bank search. I don't do them, but I send them out to do bank searches. But also if we have to do a default, in order to do a default, at least in our state, we need to go and get information from the Department of Defense, and they require the Social Security and or date of birth. So it's a lot easier to be able to submit that as an attachment to our non-military affidavit, which we have to supply with default. So if I see that I'm filing suit against a guarantor, I'll ask for that upfront because I want to make certain that if we do get a default, that I have the ability to get that default. If not, I'm searching and trying to find that Social Security number, which obviously is very, very hard to get. So if you have that information, that would be great. And of course, email addresses. So that pretty much covers the plaintiff, the defendant, and any personal guarantor who is also a defendant. Let's talk about items that you could possibly send. Um, Obviously, invoices. Invoices are very important. And one thing I'm seeing a lot of collection companies do is they will add in the amount that is due. If the invoice and statement of account show, let's say $10,000, they will add in automatically collection fees. I want to know about that ahead of time because I'm suing primarily just for the principal amount plus interest, plus service charges, plus attorney's fees. So I really would love to know if you're adding something else, if you could indicate that in your forwarding letter as to what you're adding and how you're adding it and how you arrive at that number. That's always good information to know. For interest, for service charge, for collection cost. Those are all good items to know so we know exactly the amount that we're collecting. Also, if you can provide the nature of the claim, is it goods sold and delivered? Is it for services? Are there services still being provided? Sometimes you'll see like advertising services, or maybe they're, had billboard signs and like, oh, well, the services are no longer provided. I like to know that because if it's services that have been discontinued, then that's sort of important. And whether or not you're going after what was previously supplied and not paid for, or whether or not as a result they signed a contract for that billboard sign, which which the client paid for, and to have that billboard sign put up, and now they're not paying it anymore, and that sign's gone, and now you're seeking, for the future costs of the contract that the debtor did not fulfill. So the nature of the claim is certainly nice to provide. Provide any contracts, credit applications, critical. Any bank account information, if you have that extra information that's not in a credit app. A good credit app will have references. It'll have bank information. It'll have that social security number, date of birth, if there's a guarantor in it already. That's always an important thing. Obviously, a personal guarantee. If there isn't, we need a copy of the PG. I always would recommend, although this is not something that's in you all as collectors, recommend having a separate document as a personal guarantee, not included as a part of the application. It's nice to have a separate and distinct document, but that's another seminar. If you happen to have a driver's license of the guarantor or driver's license of the principal resident, that helps as well. especially because then I can, if we're having difficulty finding the person, can go on the court records and see whether or not the person has a traffic ticket. And all of a sudden, oh wow, there's a recent traffic ticket. Oh wow, they got served here, and that's the address that they were that they supplied to the officer, and it's still a valid address because they're fighting that traffic ticket or something minor that I may be able to get on the court records. Purchase orders, if you've got those, that's awesome. Um, emails for the particular orders. If you're not purchase order, emails. Oh yeah, please send me that, for 10 crates of oranges, things like that. The statement of account, which is nice to have because that's a sort of the summary of all of the invoices. And then, of course, like I said, the invoices themselves. Delivery tickets, proof of delivery. A lot of times people will send me proof of delivery and they're wonderful and they're there, but they're not signed. And that's a little frustrating because then the debtor says, oh, yeah, I have the proof of delivery, but it's not signed. So if they're not signed, and if they are signed, that scribble that we all do, it's really nice if that, at least this is advice you give to your clients, that it's not just scribbled Joe Smith. It actually is, a signature and then maybe says Joe Smith so that we can identify who signed for it so that the person say, well, I don't recognize that signature. I don't recognize the person's name. And then all of a sudden you say, well, wait a minute, Joe Smith is the principal officer or an officer of the company. You can make the correlation. So that's always nice. I've had one recently where they sent me pictures of the delivery truck. They're available. If they're available, send them on. And it shows the delivery truck. It shows the house in the background as they're delivering the roofing supplies. And there's a picture of everything. Picture's worth 1,000 words. And even on the pictures, it'll have the date, it'll have the time. And it was perfect at a recent mediation. I showed that, and it was what I needed to get me over the hump when the debtor was saying, "Oh, I never got anything." Um, any bill of lading that you may have as a part of the file, supply that. Um, any particular disputes, that's the first thing that I ask for. I really love to know what I'm getting into. These are the emails that we got back and forth from the debtor saying this was the problem about this particular goods or these particular supplies, or the equipment was supposed to be 10 feet and it only came back 9 feet. Love to know about that ahead of time, especially before I'm filing suit, because the last thing we want to do is get involved in something, find out that it's now being litigated, and then not know at that point that, well, wait a minute, I did not know that piece of wood was supposed to be 9 feet and now it's only really 10 feet. You'll have to know about that ahead of time. And I think clients want to know about that ahead of time as well, because they want to know, are there going to be just affirmative defenses in response to the claim, or are there going to actually be a counterclaim? Well, you sold it to me at 9 feet, and as a result, I ended up installing it, had to hire somebody else to get a new piece of wood, reinstall it. It cost me so much more money. The customer got all upset, and now they're suing for a counterclaim, which the client says, well, I didn't expect this when I was getting into it. Now all of a sudden I'm now having to defend a claim. So it's good to know about that. Especially with any type of prior communications that you may be able to send in emails, in letters, or anything. Payments. Have there been any payments at all? That's always nice because that sort of shows if they were going to pay for that $10,000 bill and they paid 1,000 or 2,000, it sort of shows that they were intending to pay. And not only that, but it helps us with banking information. Even with ACHs or bank wires, you can even, if you look on your account, you can actually see where it comes from, and you can take that banking information, not the banking information, but on a wire on your account. You can take those numbers and you can plug them into to Google, and all of a sudden it will tell you it's Bank of America, it's Chase, it's TD. It's sort of helpful if you have that information, because then we can get bank information without them even knowing it, because they've sent you a prior payment. So that pretty much covers, I think, what you would supply um, as a collection company. The items you would supply, the information you would supply, covers what we need about a creditor and what we need about debtor, or from a debtor, and then of course the parent personal guarantor. So
Jeff,
that's pretty much
I have a
it.
question that came in from Lacey. She says, as far as Social Security numbers go, is it illegal to pass via email from the collection agency to the attorney handling the post-judgment efforts?
I'm not aware that that would be illegal. I think, or I think what, if you're going to do it, a lot of times it should be sent maybe on a secured website or a secured email. Um, if it's something that you feel uncomfortable about, you can certainly call and do it over the phone. But if you've got the information in front of you and you're skeptical about setting it, and I would too, I can understand how being sending it over just a random PDF that anybody could get a hold of these days. I think that it would be wise to perhaps send that in more of a secured manner.
Great advice.
I have a question.
Anybody?
Yeah, I have a few
Yeah,
questions. So Jeff, you had mentioned providing the accounting person's name at the debtor company and that being helpful. How is that helpful for you?
It's helpful because then normally, let's say it's a larger company and normally it's the accounting department that, or the accounts payable department that handles the bills. So then I know let's go right to the source within that company. So that's the reason why I like to have that information. I guess maybe I guess the better way is the accounts payable clerk to be more specific so that I know who I'm supposed to contact directly because the principal officer may not even know that this bill's outstanding, but the accounting office within the business may know.
Okay. And I have one more. So this one, it might be a little bit broader, but you had mentioned about whether a creditor who's, ultimately providing the claim, they're owed the money. You asked if we could provide documentation conveying whether they're authorized to do business in the particular state of the filing. So if they're not, how do you deal with that?
You mean you're talking about the creditor?
Yeah.
Well, it's a legal thing that, whether, if they're now doing business in the state of Florida, they have established contacts in the state of Florida because they're actually operating here. It's never really an issue that I have found because normally when they're doing business, it's not a regular occurrence. And I don't think that the debtor would end up saying, well, you do not have the ability to do business here. Um, but I think the mere fact that they actually transacted business in Miami, they sold the goods in Miami, and the debt is owed in Miami. I think that would establish jurisdiction in Miami for that particular debt.
Perfect. Thank you.
Yeah, but it's nice to know if that particular company is authorized to do business, in the state of Florida, and a lot of the larger companies already are registered to do that. So
any other
that's
question? Oh,
go ahead.
Lacey's
Go for it.
Lacey's got a follow-up, Jeff, if that's okay. Please explain what it means to be able to do business in a state versus where you should not be.
Do business state where we should not be. I'm not sure I understand the question.
So
So in a
Lacey, you
state where if they're licensed to do business in that particular state, what would constitute them as not being licensed to do business in that state?
Well, I don't. You're talking about the creditor, or you're talking about
The
the
creditor,
debtor?
yes.
I'm
So like
sorry.
if we couldn't file suit because they were not licensed to do business in that state.
No, I think you still could. I mean, if the if if a company out of Georgia sells product to me in Miami and my company in Miami, and it was sold here, the transaction occurred here, they didn't pay the debt here, and the transaction occurred here, I believe you could still pursue the action against the debtor. Plus, the debtor's located here in Miami. It would not prevent them from doing so.
Okay. Where would it become a problem for that type of situation?
Hmm. I don't know. I don't think that it would be. I don't think that it would be. And Gil is shaking his head no. So, Gil, do you have any thoughts on that?
you got to take yourself off mute. Yeah.
The only other thought I have, you're absolutely right about that. It does not pose a problem, but also the Commerce Clause to the U.S. Constitution provides that you can do interstate business. So, and there's 20 different arguments you can make. once in a while, and it's fewer and fewer. Years ago, you used to get a lot of these arguments. Well, they're not licensed to do business in the state of Florida. You get a motion to dismiss. You rarely see that anymore. At least I'm not. Maybe once a year, twice a year by some lawyer who thinks they're being creative and, you
Yeah,
know, but I don't see it. I don't see it as a problem. It's interstate commerce.
yeah. Good point. And the other thing, Gil, and I'm sure you guys would agree with this as well, is that if they're doing business here and they're trying to kick it out, that's the last thing they want because all of a sudden it comes in their state, their backyard. They would love it if you sued them here and you're in Georgia because now you're in the debtor's backyard, rather than having to push you out in Georgia. And now they have to get a lawyer in Georgia to defend the claim if that's the case. So it's nice to they probably like the fact that it's, you're suing them in their backyard.
And just to clarify, we're talking about the creditors here.
That's correct. That's correct.
Because we're not talking about agencies, whether they are
No,
licensed to do business. So I just
no,
want to make that clarification.
absolutely. So
Yeah,
it's
definitely the creditors is what I would, because we have had a couple of people who are, oh, they're not licensed to do business in this state. So since we have a lot of people on here, and we've got a lot of people in our department as well over at Altus, I just kind of wanted some clarification on that so that we're all kind of
yeah.
in the know.
Have not seen that in years. I think so. I think that you're going to rarely see that argument because the debtor would rather be sued in their home state, in their own home county, because then they can use their own lawyer and it's close and they're closer to the courthouse and they require the plaintiff to travel to where the debt is.
Right.
There could be jurisdictional clauses that prevent that. Sometimes that's an advantage. Say, listen, you can only sue in a particular county and the creditors. I always bring that up to clients. That's actually a good question to follow up. I always bring it up to a client and say, well, there's a jurisdiction issue and the jurisdictional clause, we could sue them here. And, but at the same time, they could say, well, no, you can't sue me because of the jurisdiction clause. I always bring it up to the client, but rarely do I see somebody says, well, wait a minute, you can't sue me here. I want you to sue me in your home state. But it could happen. Seeing a couple of questions. Annette, go ahead.
Larry said, you mentioned ACH and wires will identify the bank where the payment originated. We had an example where our attorney's bank refused to disclose the account information that would have assisted us in proceeding with a bank levy. Have you encountered that issue in the past?
Great question. The answer is, like on my trust account, if I get a wire from a prior payment, it will actually say wire, the XYZ Corporation, and then it'll have some numbers that follow. Those numbers, I don't know. I think it's probably the ABA number. I put that number into Google, and all of a sudden it says, "Oh, it's Chase Bank," or it's such and such bank. If they're not there on my trust account information, I have a good relationship with my bank officer, and they then will go ahead and I'll say, "Hey, listen, where did this wire come from? Where did this ACH come from?" And a day or two later, they'll supply that information to me.
And Lacey says, yes, if you search the routing number, it will tell you which bank it is.
Yep.
Lacey, you also mentioned governing law versus exclusive jurisdiction. Do you want to amplify on that?
Yeah, just like what's the difference? We've had a couple contracts where some of them just say governing law, some of them say exclusive jurisdiction. And since you kind of brought that up, I figured I would just kind of throw that one out there. Like, does governing law, is it the same thing as exclusive jurisdiction?
No, so two different things. So what they can say is the governing law of the contract is in New Jersey, and in New Jersey will have exclusive jurisdiction as to where you can file the action or where the venue is. So the governing law would cover the law of the contract, and the jurisdiction of the venue could be cited in that application as to where you would file suit, where venue is or where jurisdiction is. So two separate things. Although they sound somewhat similar, they do mean two different things.
Okay, so basically, if it mentions governing law in the contract, but it does not say anything specific towards exclusive jurisdiction, then you can file in the debtor state.
I believe that would be correct.
Okay,
And then the governing law of New Jersey would apply even though you're filing suit in Florida.
thank you for the clarification.
Thank you. Great question.
Tom has a question about a statement first that says clients are skittish about providing witnesses. Are there statistical metrics we can access regarding chances of needing a witness? That's a
No,
good
Tom,
question.
they're
Maybe
not.
that's an association question. Maybe that
Yeah,
should be an association survey that should be done. Thanks, Tom, of course.
yeah. I
Is
can tell
providing
you,
a witness more or less common post-pandemic?
well, I was just about to say it's less common. I was speaking with the judge the other day that I saw, and she says, I just got from the house. I'm like, what do you mean? So the judge is doing Zoom trials out of her house rather than at the courthouse and accepting witnesses by way of Zoom. So I think in this day and age, with everything really being Zoom, except for maybe special set hearings and maybe certain trials on smaller type cases, I think it's not prohibitive if you were to file a motion with the court and say, and ask for permission that that particular witness appear via Zoom. And as long as you can set up maybe somebody that could swear the witness in properly within that particular, where that person is located, I would venture to say that judges will have a tendency to grant it. It just also, it depends on the judge, depends on the location. But I would think that the judges are going to be somewhat lenient in this day and age where most of the stuff is Zoom. I used to hop at the courthouse, go to motion calendar for a calendar call, everything. Everything's now Zoom. The only time that I'm really going to court now is either for a trial or for a special set hearing that lasts longer than 15 minutes, where a judge requires it. Some are very lenient, some require some say Zoom's fine.
And for the Jeff, for the agencies that are not attending those on a regular basis, I mean, very few and far between, since the pandemic, has the Zoom platform or the Teams platform, whatever jurisdiction, has that gotten easier and less hiccups? I would imagine so. Like, there's not disconnections or missed links or anything like that. They've perfected it.
Yes. And judges have their own Zoom address and their own code. So it's on your note on the notice, you actually will take that information, you put it on your notice of hearing, and it's like you plug it in, boom, and all of a sudden it goes to Judge Smith. They've made it pretty easy. And the judges are using it, and I think the judges like it a lot because, like I said, this particular judge, she works in North Miami, but she lives in South Miami. It's an hour and a half drive, and now she's operating out of her own home, her business. So even judges are operating remotely if they can.
Yeah. Anybody else have any questions? You can just ask. You can take yourself off mute and ask now. All right. Well, it's the 20-minute talk has turned into the 35-minute talk. So, in respect of everybody's time, I want to thank Jeff Rubin from Tallying Off Rubin and Rubin. Thank Alex Rosen for introducing. Just remind everybody on the call that the next 20-minute talk is February 12th. And a little bit further down the road, if you are interested in an in-person conference, if you haven't seen the announcement, CCA of A will be meeting in Austin, Texas, April 19th through the 22nd. The conference is full of in-person, not only CLEs for the attorneys, but continuing education for the agencies. So, and a lot of networking. So, the registration will be opening up at the beginning of February. Thank you, everybody, for joining. And if you want more of this, just look on the website. There is a library of past TMTs. Jeff, we really appreciate it. Thank you.
Thank you. And
Thank you.
thanks to Gil for helping me out on that spot there. I appreciate it.
All right.
See you guys. Bye-bye.
Bye.
Bye-bye.
Bye, everyone.